Good evening, everyone. Welcome to our Monday, December 14th, 2020 regular school board meeting. Before we begin the work of the district, let us stand for a moment of silence, followed by the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. And we're going to take just 1 minute. Dr. Burns, you have an opening statement?
Yes, I'm here at home because we are being careful of COVID due to a family reason.
Well done, thank you. Okay, any changes, amendments, additions, or deletions to the agenda? We're good?
The only thing I have is there's a revised contract language that was added today to the contract in item 8.18 under section 8, jurisdiction per the attorney, and you have a copy of that.
Superintendent, approval of minutes?
I recommend approval of the minutes from the employee hearing held pursuant to Florida Statute Section 1012.33, 6A1, October 26, 2020, continuation of hearing November 5th, 2020, regular school board meeting November 9th, 2020, special meeting investiture and organization of the board November 17th, 2020, and executive session for collective bargaining.
So moved.
Do I hear a second?
Second.
Any discussion? All those in favor?
Aye.
Aye.
Any opposed? None? 5-0. Representation. I have one card. Mr. David Serdar.
Hello, Lake County School Board members.
Mr. Serdar,
Oh.
Mr. Serdar, before you begin, if you'll bring your mask up, perfect. And your name, and you have address, and you have 3 minutes.
David Mitchell, Serdar, 66 Wintergreen Drive, Fruitland Park, Florida, 34731. Well, you know, I used to work for the Lake County Schools at Leesburg High School. I have some things to get back to you. This is expensive, and what I got in this bag, this is, well, you have approximately an 18 or 20-inch vacuum cleaner that's worth so much money. And I was a probationary employee. I was doing so much work, you can't believe it. And I'm part of a society that's anonymous. And I was talking to Mr. Neal, the principal at the time. Mr. Chua was in charge, an assistant principal. I'd love to get my job back because I've talked to many kids that are high school students. Because Leesburg High School was in the Lady Lake Parade and the Leesburg Parade, and so was I. I was picking up trash behind Santa Claus as I did last year. I mean, I just came from the Orlando City Council meeting on Monday, and, you know, it's Christmas season. I've got a bell in my pocket. I volunteered at the Salvation Army in front of Walmart, which has the most theft of anybody in the state. Orlando told me I brought in the spirit, and Chris Castro, the Sustainability Residence Director, came out, and I got a picture in my pocket. So happy after the meeting as we text each other. He's getting sent to the Vatican. You know, I've written a letter to the Vatican. You know, there's too much drinking and drugging. And in high school, I saw my first bag of dope. That guy's dead from heroin. In a gym. Locker room. You know, Orlando? Yeah, I was there. And Buddy Dyer went to Boston University. And Suffolk County wanted to make a pin and give it to me because I go to that board meeting on Tuesday, what is it, December 8th. Orlando's was the 7th. Marion County is tomorrow. I get around. But Buddy Dyer went to Boston University and he majored in environmental engineering. I'm worried about our kids' future. I've been to school, health chip meetings in Lake County. You know, it's going to be Christmas time. My dad, I played sports. I'm so red, white, and blue. Salvation Army, what a great thing they do. They're giving out toys, Toys for Tots, they're giving out toys. You know, and I handed stuff out and let them know. A lot of people are taking the toys and taking them back to Walmart in Leesburg. They said, by God, the service counter said, we're gonna get them back. Well, I mentioned that to the Marine people, Toys for Tots at Mr. Phillips' dealership, that you can pick up toys if you don't have any for your kid's future. I got flowers for you folks. I've got cookies for you folks. My wife makes cookies. My dad was a principal for over, what is it, Dad? 36 years. He passed away 2 years ago. And I've shown these to you folks before, but Mrs. Cunningham, I don't believe you've seen them. But God bless you for being on the board now, and I've run into you before. You're the first person I shook hands with at a caucus down in Clearmont. I go to Clearmont. I've been to those meetings.
Thank you,
I
Mrs.
thank you for
Serdar.
your time, and happy holidays to everybody.
Merry Christmas to you. Thank you very much for your constant support of our kids. Okay, reports. Education Foundation. Do we have anyone here? Where's, oh. Carmen. You can, Mrs. Cullenbat, you can go ahead and begin.
Okay, thank you. Applemart has had 434 teacher visits, and we've distributed $32,500 worth of supplies. The Duke Energy Robotics Scrimmage has been rescheduled for February the 13th at Tavares Middle School, and 16 teams will be invited to attend this event. Last year, we were able to bring in 32, but being cautious, we're only going to bring in 16 this year. Our board has awarded 23 matching grants in the amount of $52,000. Co-trustee Karen Bent from the Marion Shuck Trust has given us an additional $6,500, so we could award 3 more for a total of 26 awards. We received $5,000 from Florida Blue, and we were selected for a donation from the Eustis State Playhouse. The Teacher of the Year celebration is January the 28th and is being held in 45 locations. The live event is at the Venetian Center, and on the 13th of January from 4:30 to 6, we are doing a pre-recorded with all nominees, and school board members are invited to come to that from 4:30 to 6. It'll be a small reception. It'll give you the opportunity to meet all of our Teacher of the Year nominees. Take Stock in Children received a notice that they would be getting a hold harmless refund of over $12,000 from Florida Prepaid Foundation. The emergency procedure kits that we would like to thank the Sheriff's Department and Matthias Food Service for helping the foundation fund will be ready for distribution this week. And the Holiday Foundation Party Squad, the superintendent and Miss Leesburg delivered cookies to 32 district departments last Friday to wish them a happy holiday in lieu of our annual holiday district Christmas party. There will not be a foundation board or an executive board meeting in December. And our foundation offices will be closed 12/21 through 12/31. And on behalf of the board and staff of the Education Foundation, we wish you and your families very, very Merry Christmas and Happy Holidays. Any questions?
Thank you, Carmen. Merry Christmas to you too and your team. Great work.
Thank you.
Okay. Attorney's report?
Nothing.
Okay. New business, Superintendent.
We have no unfinished business, so we're going to move on to the consent agenda, if that's all right.
Correct.
Recommend approval of consent agenda items 8.01 to 10.06.
So moved.
Second?
Any discussion? All those in favor?
Aye.
Any opposed? 5-0.
Mr. Johnson.
Oh, I'm sorry.
We're on the first discussion item.
Yes, ma'am. Item 11.01 is final approval of revisions to policy 6220, budget preparation. If there's anyone here this evening that wishes to speak to this particular item, then please come forward at this time. Madam Chairman, is there anyone in the video room or, nope? Mr. Chairman, excuse me.
You saw the feminine side of me.
I don't believe anyone's coming forward and believe it appropriate to close the public hearing portion.
Superintendent, we have a recommendation.
I recommend final approval of revisions to policy 6220, budget preparation.
So moved.
Second.
All those in favor?
Aye.
5-0.
Mr. Chairman, excuse me, item 11.02 is final approval of policy P00165.6, use of electronic media technology for meetings. If there's anyone here this evening that wishes to speak to this particular policy change, then please come forward to the podium at this time. I don't see anyone coming forward, Mr. Chairman, and believe it appropriate to close the public hearing portion.
Superintendent, a recommendation.
I recommend final approval of policy P00165.6, use of electronic media technology for meetings.
So moved.
Go ahead.
Second.
Okay, well done. Okay. Let's have a vote. All those in favor?
Aye.
Any opposed? 5-0.
Next item, Mr. Chairman, is 11.03, final approval to rescind policy 5517.02, sexual violence. If there's anyone here that wishes to speak to this policy, then please come forward to the podium at this time. Mr. Chairman, I don't see anyone coming forward and believe it appropriate to close the public hearing.
Superintendent, recommendation.
Recommend final approval to rescind policy 5517.02, sexual violence.
A motion.
So moved.
Second.
All those in favor?
Aye.
5-0.
Next item is 11.04, final approval of new policy 2266, non-discrimination on the basis of sex in education programs and activities. If there's anyone here this evening that wishes to speak to this particular policy, then please come forward to the podium at this time. Chairman, I don't see anyone coming forward and believe it appropriate to close the public hearing.
Superintendent.
Recommend final approval of new policy 2266, non-discrimination on the basis of sex in education programs and activities.
So moved.
Second.
All those in favor?
Aye.
Opposed? 5-0.
Next item is item 11.05, final approval of the amendment to the 2020-2021 Code of Student Conduct and Policy Guide. If there's anyone here this evening that wishes to speak to this particular matter, then please come forward to the podium at this time. Mr. Chairman, I don't see anyone coming forward and believe it appropriate to close the public hearing.
Superintendent, recommendation.
Recommend final approval of the amendment to the 2020-2021 Code of Student Conduct and Policy Guide.
You have a motion?
So moved.
Second.
All those in favor?
Aye.
5-0.
Mr. Chairman, the next item is 11.06. This particular matter is two parts. One is a hearing on exceptions to the administrative law judge's recommended order in the case of Lake County School Board versus Todd Erdman. The second part is a discussion and decision on the final order in the same case. I believe both Mr. Erdman and the school district are present by counsel. Is that correct? let me back up a minute, so just procedurally where we are and what your job is tonight to do. This was a situation where the superintendent made a recommendation to terminate an employee. That employee exercised his rights to due process hearing and elected to utilize an administrative law judge. That administrative law judge held a hearing, and there was evidence presented and testimony taken by both sides. The petitioner in those hearings is the Lake County School District, and the respondent is the individual employee. At the end of an administrative law judge's hearing, he takes or she takes proposed recommended orders and then puts together a recommended order of the administrative law judge's own drafting. In this particular case, the administrative law judge heard the evidence, made the decisions, and completed and presented to the school board a recommended order, which I believe that you all have either seen, have in possession, or have had an opportunity to look at. That particular recommended order has at the end of it a notation of the employee's right to, or actually either party's right to file exceptions to the recommended order. Exceptions are kind of like objections. There's some part of it that you think is incorrect or not appropriate or doesn't follow the law. They can file exceptions. In this particular case, the employee filed exceptions, I believe 6. Yeah, filed 6 exceptions. I believe you all have been provided a copy of the recommended order and those exceptions. And additionally, the attorneys for the school district and superintendent filed a response to those exceptions. What we're going to do now is that both parties will be given an opportunity to present their case as to why the exceptions should be or should not be included in any or modified in any final order that's entered. I've spoken to the chair, and I believe we're going to, either side is going to get 10 minutes apiece to make whatever argument they would like to make. We'll start with the party, the employee, because the employee was the one that filed the exceptions, and then the attorney for the district will be allowed to present any response to that argument. That will conclude the lawyers for the districts and the employees' involvement, and then at that point in time, the board will be in a position to discuss and take any action regarding the exceptions, and you're required to look at each one, and we'll go over what the standard of that is when we get to it. And the second thing that you'll then do after you make a decision on the exceptions is that you'll take a look at the recommended order and make some decisions regarding the recommended order and moving forward with that. So with that, Mr. Chairman, I believe it appropriate that the attorney for Mr. Erdman be given an opportunity to make his presentation.
Can I ask a question before we start? Are we able to ask questions during this, or is this just sit and listen?
You are permitted to ask questions, yes.
Thank you.
Would you like to come forward? Whatever you'd like to, whatever you're comfortable. Sure. And we have, unless you're concerned with the
I'm
mask,
not.
I have a hard time hearing.
Can you hear me or no?
It's yeah,
Is that better?
way better.
All right,
Thanks.
I'll just take it off momentarily.
Okay, thanks.
I got my temperature checks. So
Okay,
we're
good.
I'm here on behalf of.
I'm sorry, could you state your name?
Oh, I'm sorry. My name's Nicholas Wolfmeyer. I'm from Egan Lev, Lindstrom and Zwick law firm. We represented Mr. Erdman for the FEA and the Lake County Teachers Association in this matter. We filed 6 exceptions in this case.
I
We're not-
apologize, your last name again?
Oh, I'm sorry, Wolfmeyer, I'll spell it for you, W-O-L-F, as in Frank, M-E-Y-E-R.
Thank you.
Again, we filed 6 exceptions in this case to the recommended order, which was argued by Mr. Lindstrom at hearing. The first one is the responding, being Mr. Erdman, accepts the paragraph 39 because it improperly shifted the burden to him and incorrectly stated the factors to consider in making credibility determinations. Normally, when making a credibility determination, you sitting in front of someone, you look at their demeanor, physical appearance, gestures, to determine whether or not they're telling the truth. In this case, instead, the ALJ listed a bunch of factors that Mr. Erdman would have had to prove in order to make his case. The second one is the respondent takes exception to paragraph 51 that states that students, parents, and school district personnel viewed and became aware of the videos. This is an unusual case because there was no direct testimony called from the district of any student, 0, who said they viewed the videos. There were a couple parents that testified as to what their children said to them, and this is, I guess, more of a legal argument, but that's considered hearsay, and that's not acceptable for a finding of fact. The third exception is paragraphs 52 through 59 in their entirety. And this is a big problem with this recommended order, and this is not the school district or their council, no one's fault. But reading this order, when you look through the ultimate findings of fact, what it does is it gives a list of facts that the respondent purportedly did, and we're not going to argue those here, but, and then it says you broke all these rules because you did these things. Normally, when you read these recommended orders, and I'm sure you have one or will have another one someday, you'll say, you know, so-and-so broke this rule and he committed assault because he hit someone. But that's not the case here. It says he did that, he made this video and he did this and he did this, but there's no connection to how those interact with the school board rules. And we think that's a violation of his due process, because if he was to go to an appellate court, they're not going to know the facts or the transcript and how they're going to connect those things. The fourth exception is number 75. That goes along with the same, with exception 3. This is just a little more specific. So again, for example, 75B says TikTok videos contain lewd and offensive material. Now, one of the things Mr. Erdman was, the rule he supposedly violated was that being honest in his professional dealings. Obviously, creating TikTok videos, we have no idea how that has to do with being honest in his professional dealings. Again, this is no fault of the school board or the council. This is just the case of a very unusual recommended order that came out. Also, footnote 3 to paragraph 75, the ALJ cited a case that said if you post something on social media, you have no right to privacy, regardless of how your privacy settings are. And this is, we think it's just flat out wrong. He cited one case which talks about Facebook, where someone put their privacy settings to only friends. In that case, the judge said, well, if you have it to only friends, your friends can share it, so therefore you have no expectation of privacy. And in this case, that's not simply the case, at least from the respondent's point of view. He had it on only me, the only person that could see it with him. And if that's the case, from a legal standpoint, we believe you have an expectation of privacy. Whether or not you believe Mr. Erdman or not, that's not the issue. The issue is with that area, that case cited by the ALJ. Exception 6 talks about immorality. There was, again, no explanation given about how he was supposedly immoral as to not follow progressive discipline, which is in the CBA. CBA allows for termination if you're for immorality is the legal term. But again, that has specific elements from a legal perspective. that the teacher engaged in conduct inconsistent with the standards of public conscience and good morals, that the conduct was sufficiently notorious, and it impaired his effectiveness in the community. Again, the ALJ did not connect or develop any of those arguments. We're not sure that all of those factors are met, and even if he did not connect them to his legal conclusions in the order. Therefore, there'd be no competent substantial evidence at play. Moreover, and I'll make this brief, I'm not going to go the whole time, the big issue in this case is this case was off-duty. No one questions that. No one's alleged that the respondent was on duty. No one's alleged that he used any equipment from the district or that he did it on the district time. This happened over the summer. It was unfortunate. Students saw this. But to terminate someone for that, even, and I'm not saying that he did, because I don't believe he did, but even if you believe that he openly shared these things, when you delve into an employee's personal, private, social media life, that, one, goes against some of the case law, which says that off-duty conduct in that situation is not misconduct, as the law suggests. But the other thing is it opens up a lot of other issues when you talk about other employees. Are you going to investigate or rely on reports from any social media of any employee, down from a custodian? I shouldn't say down, because they're very respectful and very important, to yourselves, school board members. I know a couple of your school board members' videos themselves were made evidence in this case. I didn't do that, and I'm not going to talk about that. But again, that sets a very different standard and it opens a big can of worms if you're going to start disciplining and even terminating personnel for things that they did away from work over the summer and in their own private lives. Finally, honesty and professional dealings requires proof that the educator knowingly intended to deceive or defraud the school board. There's no explicit allegations that he lied. There's some inferences, but there's no allegations that he lied or violated that rule. And courts have held that to embarrass a student, you have to consciously choose not to comply with the rule in embarrassing a student. That was not present in this case. And then finally, no school district, the board rule 6.3014, at the time of the offense stated no district employee shall engage in conduct unbecoming of an employee of the school board that brings the district into disrepute or that disrupts the orderly process of the district. And typically, again, this is a legalistic argument. You usually bring someone in and say, this is what the school district expects. Here's the standard, and that was not done in this case. So therefore, we accept that finished up exception number 6, which was, I believe, to paragraph 76 and 77 in the recommendation as well. If you have any questions, I'm happy to take those. If you don't, that's fine as well.
Start with Dr. Burns. We'll start with Dr. Burns. Do you have any questions? You're on mute.
I don't have any question. I don't know if they're questions for him. I just have questions like of points that he brought up, like does this go to the appellate court, and at what standard? I don't know if that's something for him or because he mentioned that this wouldn't stand up in an appellate court, but I don't know if this is an appellate court.
Well, I think that right now we're going to hear both sides, and then we're going to have board discussion. So you're
Yeah.
going to stand by, right, Mr. Wolfmeyer?
Yeah, I think I'll wait then.
Okay. Okay. We'll excuse you, but we'll want to speak to you probably in a few minutes.
Thank you.
Okay, next.
go, if that's okay?
Perfect, thanks.
All right.
May we get your name, please?
Sure. Patty Chapman.
Okay, you'll have 10 minutes.
Okay. I'm going to try and not take up all 10 minutes. I don't think I'll get close to it. I think you all are familiar with the facts of this case, so I'm not going to belabor them. I'm just going to address the 6 exceptions head-on with a little bit more, I guess, meat and potatoes, so y'all can have some facts to decide upon when you're thinking about these, when you're making this decision. Before I get to the specific exceptions, just briefly want to touch on your role, and Mr. Johnson will talk about that too, but really you can own, the board can only overturn a finding of fact if they find that there was no competent substantial evidence to support the judge's findings. So even if for whatever reason you were to agree with Mr. Erdman's theory, if there's evidence that goes against Mr. Erdman's theory for the judge to have made his findings, then you can't go against what the judge found on the findings of fact. So really what's important for y'all to think about, and that's what I'm going to try and point out, I'm not going to do pinpoint citations. I drafted a response with very specific parts of the record where you can find where these facts come from. But the main point is that there was an abundance of evidence put into the record upon which the judge could make these findings of fact. And for that reason, I'm going to ask at the end of this for you to uphold the order, because there is no basis for y'all to overturn it, because there's facts that support it, whether Mr. Erdman agrees with it or not. Okay, so the first one is this exception to paragraph 39. And the basis of Mr. Erdman's argument is that he says that it makes a credibility determination. I don't read that paragraph to make a credibility determination. If you all look at it, all it does, it states what the judge is doing is saying, for me to believe Mr. Erdman's theory, I would have to believe his explanation of how the videos went public. And it just lists straight from Mr. Erdman's own testimony what Mr. Erdman said happened that caused the videos to be made public. He doesn't really make a credibility determination in that paragraph. He's just lifting facts straight from Mr. Erdman's own mouth. Okay, so I don't think the exception applies even. It doesn't make sense to me, candidly. So for that reason, I would say you deny it. But even if you all were to think that it does talk about his credibility, there is an abundance of competent, substantial evidence upon which the ALJ found that his credibility was at issue and did not agree with his theory. The crux of this case, as you all know, is there was these TikTok videos. You're not going to hear any, and you didn't hear any objection to the fact that Mr. Erdman's in the videos. He created the videos, he put them on TikTok, and the videos are absolutely lewd and offensive. And there's no objection to that. So really what the case turned on is how these videos were made public. How did they get into a student's iPhone so that they could watch it and spread it around? That really was the crux of it. And so why the judge went into those details is because the judge was saying, okay, for me to agree with Erdman's theory, I'd have to believe all these things. So, which, and don't want to get ahead of myself, I'll get to that in one of the other exceptions, but there was competent substantial evidence to support finding that he was not credible, and I'll get to that in a second. I don't think it applies to this first exception, though. So on exception to paragraph 39, we would say that you should deny it. Respondent's exception to paragraph 51, and that is the judge's finding that students, parents, and school district personnel viewed and became aware of the videos. The fact that no student came in to testify about what they thought about the videos has nothing to do with whether or not the students viewed the videos. From a very basic standpoint, of course students saw the videos. That's why we're here today. If no one saw the videos, Mr. Erdman never would have been terminated. But going specifically to the evidence that was put in the record, and again, there's pinpoint sites, I'm not going to go into them, but there was an abundance of evidence to establish that students, just the sheer fact that students saw the videos. There was evidence from the superintendent about how she became aware of the videos. There is evidence, and that included that employees of the school board and some school board members themselves saw the videos because they're the ones that passed it along to her. There's evidence from that employee relations received a number of calls from parents and other employees of the school board, so that's competent substantial evidence that people saw the videos. There's evidence from Ms. Cooper, who did the investigation, and she testified that she received some of the videos from the students. That's evidence that students saw the videos because they couldn't have passed it along to her if they hadn't seen them. There is evidence that two parents came in and testified, and they testified that their children, who are students, saw the videos and showed it to them. And so the list goes on, but it is clear that students and parents and school board personnel saw the videos. Whether or not students talked about what they saw in the videos is irrelevant. What they're challenging is this idea that whether or not students saw the videos. Plenty of evidence that says there is. So we would ask that you deny that exception. On the next exception, to paragraphs 52 through 59, that's really kind of the meat and potatoes of their argument. And it's the same argument they make, like Mr. Wolfmeyer said, he even reiterated that. Exception 4 is the same argument, and exception 6 is the same argument. And what they're saying is that because the judge made all these findings of fact, and then said, as a result of those findings of fact, we find that he violated policy, and then just went through the policies, that you all somehow can't accept that, and you have to read the specific paragraphs of the order in a vacuum, and that is not true. You can read the whole order in its entirety, and it's clear that the ALJ made findings of fact, and then he said, based on these findings of fact, I find that Erdman violated policy ABC and went through them. The main findings of the judge, and these aren't paragraphs that respondent has objected to, but I think it'll make it easier for you all if I just go into what the judge found, because that's why he found that he violated those policies. So the crux of what the judge found is, one, Erdman created these videos. No one's saying that he didn't, he's in them. He put them on his TikTok account. The videos are offensive. None of that is objected to, okay? So the next part is what they take a little bit of exception to. This goes to the credibility thing that I talked about at the beginning. The ALJ found that Erdman's explanation as to how the videos went public was not credible. He found that Erdman either posted the videos himself and lied about it, or he did not take all the precautions he should have in posting those so that they went out into the public. And that the last part is that he said the judge found all of that, and then also obviously students, parents, and faculty saw it, and based on those main findings is how we found that he violated all those policies. And there's competent substantial evidence to establish all of those, the things that I just talked about. They don't challenge that the videos are offensive. They don't challenge that Erdman's in it. On the credibility thing, now I'll touch upon it real quick. Even though they don't actually formally and properly challenge that specific paragraph, which is in paragraph 50, is where the court talks about the credibility issue. That's not challenged. So I don't even think you should consider it, but because there's so much evidence to support it, I'll go ahead and talk about it just so you can feel confident in your decision. What the judge, all the competent substantial evidence that went into why the judge could make that credibility determination, I'm not going to pinpoint the sites, but there was testimony from Ms. Cooper that said she did an investigation of Mr. Erdman's, the investigation that led to the termination, and she found that it was more likely than not untrue that Erdman didn't actually post the videos. And she said that the basis for her opinion was there were hundreds of videos of Mr. Erdman that he was either tagged in or tagged on. There were duet videos wherein Mr. Erdman is seen with interacting with other TikTok users. I don't know how familiar you all are with TikTok. I am now very familiar. I was not prior to this. But basically there's split screens and some user is interacting with Mr. Erdman and he's interacting back. And so based on all of that, Ms. Cooper testified at the hearing. And this is all stuff that the judge heard. That's why it's called evidence, substantial evidence that he could rely upon. That was one thing. Then there's also Erdman's own story about how the videos went public. That didn't really add up. And that's kind of what the judge was alluding to in that paragraph 39 that they've accepted to. You know, to believe Erdman's theory, the judge needed to have believed that someone stole his phone, then hacked his TikTok account, then lifted the videos from his phone and post them on a separate TikTok account that was created that mirrored Erdman's other usernames using his birth year, that hacker reposted the videos to a new public TikTok account and interacted with other users while acting like Mr. Erdman. And those are just some of the factors that went into it, which in and of itself was up to the judge to determine whether or not that was credible. That's the other thing I forgot to point out, that the credibility determinations and hearing the evidence, that's exactly what the ALJ is supposed to do. He's supposed to hear the evidence and make these exact determinations. So long as there's credible information upon which he could make these determinations, it's really not something that can be questioned. Am I out of time? I thought I wasn't gonna go 10 minutes.
You can close.
I'll go real fast. Okay, so based on those main factual contentions, that's how the judge found that he violated all these policies. If y'all look at it, and it's in my response, it's pretty clear that they tie up exactly as they should. I did not think I was gonna go 10 minutes. Sorry, y'all, I'm out of time. But in my response, it's all briefed, and if you have any questions, I'd be happy to answer them.
If you don't mind staying, because we will have some questions.
Absolutely.
As we begin the discussion.
Ready?
We ready to discuss?
Okay. So you've heard both sides' position on the exceptions that we have to deal with, which are the 6 of the exceptions. Let me just read to you one section of the statute that deals with your obligations and the standards that Dr. Burns was asking about. The agency may adopt the recommended order as the final order of the agency. The agency in its final order may reject or modify the conclusions of law over which it has substantive jurisdiction and interpretation of administrative rules over which it has substantive jurisdiction. When rejecting or modifying any such conclusion of law or interpretation of administrative rule, the agency must state with particularity its reasons for rejecting or modifying such conclusions of law or interpretation of administrative rule. We'll skip forward a little bit. The agency may not reject or modify the findings of fact unless the agency first determines from a review of the entire record and states with particularity in the order that the findings of fact were not based upon competent substantial evidence, or that the proceedings on which the findings of fact were based did not comply with the essential requirements of law. The agency may accept the recommended penalty in a recommended order, but may not reduce it or increase it without a review of the complete record and without stating with particularity its reasons, therefore, in the order by citing to the record justifying the case. So what essentially, as far as the entire order is concerned, is telling you we have findings of fact, conclusions of law, and recommended penalties are the 3 different topics. The findings of fact are separately placed in the numbered paragraphs in the recommended order. You can disagree with a finding of fact, but you can't overturn a finding of fact of the judge unless you look at it, can cite to the record of where the issue is that says that the finding of fact should be B instead of A, and you have to have a standard that there's no competent substantial evidence that was in the record would support what the judge has indicated is the finding of fact. So there's a limitation on you can't just come in and say, well, I disagree. I think when I read this, I believed 1, 2, and 3 were what happened. You're not allowed to do that unless you can see there's no way that there's any evidence in the record you've looked at the transcript of the record, you looked at all the exhibits, you looked at the evidence, and there's no evidence of 1, 2, and 3 happening. All right? Well, then you can change the findings of fact, but you can only do it under those circumstances. The conclusions of law, you can essentially you have to show that there's not the judge is not following the essential requirements of law in making a decision, so that he's made the decision that statute A and B say that this happens and he's misread it, it's wrong, it needs to be changed. So there's a little lower standard for changing a conclusion of law, but you got to know what the laws are that apply to this particular situation. The exceptions that we're going to rule on first are not exactly the same, other than the fact that if the exception is that the judge said A, B, and C, and there's no competent substantial evidence of A, B, and C, then you say, well, that exception should be adopted. If the exception says that the judge says A, B, and C, but there is no basis for saying something differently than the judge said, because you can't go to the record and say, well, here in the record it says something differently, or here in the transcript it says something differently. The bottom line of all this is that you're sitting as judges now for this part of the hearing. And as sitting as judges, you've got to have some basis for making a difference to change what the recommended order is. The recommended order is given some preference in that it is the recommended order of the administrative hearing judge who was there, who heard all the witnesses, who took all the testimony. You have all that available for you, the transcripts. But the one difference with the administrative law judge is that he was there during the hearing and witnessed the individuals as they testified during the hearing. And so that's why essentially his conclusions of law are given in some additional weight and are a little tougher standard to say, that's wrong. So with that in mind, what we got to do is go through one by one the 6 exceptions, and our options are really at this point that we accept the exception and say it's got to be changed and we've got to change it the way the exception was raised, or reject the exception and say we're not going to change it, we're going to leave the language the way it was and not change anything, or some combination of those where you don't want to accept the exception but you think something should be changed. If you think that, then you're going to need to point to where in the evidence and where in the testimony that gives the support for making some change in the recommended order that the judge has written.
Thank you, Mr. Johnson. I've got a question. Has the board seen the videos, or have they seen the transcripts?
Yes.
I read the transcripts. I didn't watch the videos. I thought the transcripts were adequate.
I think that's important, and I've asked, because I saw them for the first time today, and it begins to really put this in total context for me. And so I've asked that I would like to ask that we view at least 1, 2, 3 of these hundreds of videos.
I can do that.
Sure, come up.
Nicholas Wolfman, I'm counsel for Mr. Erdman. I'd like to say 2 things. One, we're not objecting to any findings of fact. I think one exception is a finding of fact, which is paragraph 39. There's no question about whether he's in these videos, Mr. Erdman, whether or not they're appropriate to be played in a setting like this. And it's just whether or not, as a matter of law, you're going to sit down and look at off-duty misconduct, which didn't involve any of the school's equipment, their time, or working hours, and make a judgment to terminate an employee when you have other options. You can change the recommendation to a suspension, a reprimand.
I appreciate it, but I really think that as this floated around, it is whether or not it's off-color or offensive or warrants, and I think that this is important for the board to see.
All right. 30 seconds, and I'll briefly. I would just say that I'd just like to put an objection on record. I don't think this is relevant to the hearing. I think you have the right to view it, but if that's the case, I think you should play some of the other videos, which I don't encourage either, which involved some of the school board members themselves. With that.
But may I ask you, Mr. Wolfmeyer, are you retained by the, I'm assuming Mr. Urban was a union member, are you retained by the union to represent him, your firm?
I'm not sure the relevance of that, but yes.
Okay, thank you. That's it.
Is that?
I just was curious. Okay.
Did you want to watch the videos now, Mr. Matthias?
Yep. Yes.
Oh.
And in anticipation of that possibility, we think we've got, certainly we want to make certain that there's no issue with our license to use YouTube. And we're going to have on the website, while these are being played, a statement that the following videos may not be appropriate for some audiences. Please exercise discretion and view at your own risk. We just want to make sure if somebody doesn't want to see them, then they can make that decision. So, Mr. Matthias, there were several, obviously. Did you have the particular ones that you wanted the board to view?
There is one called Beer that I think that sets the stage, and I think that there are several in line, but let's start with that, and if everyone gets a sense about it, then we can stop there.
What are you doing? Excuse me? Are you really drinking a beer before work? You damn right I'm having a beer. What, have you been to that fucking job? No. Have you dealt with them fucking idiots all day? No. Let me do me. Thank you.
And that's him talking about his job performance. Do we want to see another one? Go ahead, load it up.
I'd like to fuck you into the middle of next week.
Okay.
Next.
I don't know if you noticed or not, but as soon as I finish eating this, you next.
You sucked that guy's dick?
Yeah, how do you think I knew that he...
Wait, but you said you only had sex with 3 different guys. You never mentioned him.
Because I never had sex with him.
You sucked his dick. What? Something like 36?
Your voice.
Wait, what is that anyway? Something like 36. Does that include me?
37.
I'm 37?
Going to class.
Oh, my God. 37. My girlfriend sucked 37 dicks.
That's plenty. Okay. Board members?
I would suggest that you take the exceptions one at a time and go through them that way.
Okay.
So the first one is exception 1, which council talked about. That was the credibility determination issue. So at this point, you can say, we agree with the exception. The judge has done something he shouldn't have, so we need to modify it. Or we can accept what the judge has written as being accurate, or you can do some combination of the two.
I say we accept.
I agree.
I think accept.
Mr. Dodd?
Accepting the exception, is that agreeing with Mr. Erdman, or is that agreeing with the district?
No, we're accepting the magistrate.
So we want to reject the exception.
You're right. I poorly worded it, so it could be confusing. I'm sorry. What we will have, vote yes or no at the exceptions. If you agree with it, vote yes, which will mean we'll have to change something. If you disagree with the exception, then you vote no, and that goes forward with the judge's order as written.
So no means yes?
Yes.
Because the exceptions came from the respondent, so
Right.
If we vote no, we are against the exception
Yes,
and for the judge's rule.
yes.
Okay, let's do this again. I vote no.
I agree.
No.
No.
Dr. Burns?
No. No.
5-0.
The second exception related to paragraph 51 of the final order. That had to do with students and staff becoming aware of the video.
So no is agreeing with the judge.
That was that students didn't view the videos, right?
Ma'am?
That was that students didn't view the videos?
Yeah.
Okay.
So no against the exception.
Is there any legit hearsay rule, which is what was the argument?
There is a legit hearsay rule that you can't establish a fact solely on the basis of hearsay. Actually, hearsay is accepted in an administrative proceeding, but it can't form by itself the basis for a finding of fact, but it might in the event that there was other evidence to support that.
Okay.
I vote no to the exception.
I vote no to the exception.
No.
I also vote no.
I vote no.
5 noes.
Okay, the third exception was the paragraphs 52 to 59. And again, these were, I agree that these were all similar to 3, 4, and 6. 3, 4, and 6 are similar findings about that there wasn't sufficient evidence to support a violation of the specific rule.
I say no to the exception.
I say no.
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 5 noes.
Number 4 was an exception to paragraph 75, and that was, I believe, similar to the exception to number 3 and 6. About an explanation about how Mr. Erdman viewed each rule when there was findings of fact, which talks about those different rules.
I vote no to the exception.
I vote no.
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 5 noes.
5 was the exception to paragraph 75 footnote because of distinguishability from that case. Since it's a discussion of the case, my interpretation was the same as what district staff council came to, and as far as that was not a basis for changing the order.
No to the exception.
No.
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 5 noes.
And the final exception is paragraph 76 and 77 about having competent substantial evidence or an explanation what immorality is. I think it was presented that there was sufficient grounds throughout the record to reflect that finding.
I vote no to the exception.
No.
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 5 noes.
Okay, with that exception, those exceptions, now the board needs to determine whether, for looking at the recommended order as a whole, whether, and these are the exceptions, these are the areas that the employees found to be that they had an issue with, that it should have been different. Now we look at the entire recommended order and the rest of it, and this decision needs to be made as to whether all the rest of the findings of fact are consistent and established, and that the conclusions of law follow the law. And and whether or not the penalty was appropriate under the circumstances, which was termination. So if you want to have some discussion first, Mr. Mathias, or we can have a decision that the acceptance of the final order would be the acceptance of all of the conclusions and findings of fact and conclusions of law that the judge found and put into the order, or you could reject the entire order, or you could say this part or this part should be changed and made differently.
Maybe just to get this started, I would move then for discussion that we accept the judge's orders, we reject the exceptions. Is that what you want?
To accept the judge's order, yes, yes, sir.
And reject the exceptions.
That would essentially adopt the judge's order in its entirety.
So that we make it as a motion and then a second?
Yes, sir.
Is that a movement? Is that a motion?
That's a motion.
Second.
Okay, discussion?
I just want to bring up that I hadn't seen those videos, and the fourth video is a quote from the movie Clerks. And I wouldn't be surprised. There was discussion in there about him being Mr. Erdman enjoying, I don't know, Star Wars-y type stuff. And Clerks is a classic 20-year ago comedy film. And that line is directly from there. So, I mean, my impression from watching that is that these were designed to be public because they're role playing to be funny, I think. So I think this was meant to be okay. So I mean, this is maybe beyond the scope, but I just thought that since I recognize that, you guys might want to know, because I was surprised. I don't know. It makes me think that it was intentionally meant to be comedy, which doesn't make it better. It just, and in the movie Clerks, it's only a conversation. There's nothing gross in the movie. But I just wanted to let you guys know. I don't know, because that I don't think that was anywhere in the discussion. So I'm guessing this is like a pattern.
Gotcha. Okay, thank you, Dr. Burns. Okay, should we take a vote? All those in favor?
Aye.
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 5-0. Any opposed? None. Okay.
Yes, sir.
Good. Okay, moving on. Board committee appointments. I think Natalie put out a new list of appointments, and we do have one committee newly formed, which is the naming rights for the district, district rights for naming schools or parts of schools or whatever. And so this was brought forward by Vice Chair Luke, and this is going to be a citizen committee. I don't know if anyone has any thought to who would belong to that. And she already took dibs on Dr. Tibbetts. So.
I did. She's from my area. Dr. Tibbetts has agreed to be my representative.
And he may have had something to do with this. I have reached out to, I'm assuming that this is going to be going to set the protocol.
Well, and so even just discuss the option of a protocol, if it's something that we want to pursue or not. I mean, I think everything's on the table.
Yeah. So it may be a 1 or 2 time meeting.
Not like an ongoing.
Not an ongoing every month or anything.
Okay.
So if you give some thought.
I actually have someone that I would like to appoint. That person did have some questions. You just answered some of those. He's a former city planner, and part of his concern was, will there be outlying ramifications given to the committee members? For example, will there be a set time? Is it a standing committee, that would meet once a month? And I think you just answered those.
No, we don't see it
So,
once a month.
okay, I do have a name.
Okay, perfect.
Do you want me to tell you now?
Yeah, put it
Okay.
on the record, because then they're hooked.
His name is Alton Roan. Last name is spelled Roane. He is from my district. He's a retired planner for the city of Eustis.
Excellent. And I reached out, and Davis Talmadge is going to be my appointee, and he's a financial planner and consultant. Todd, you have-
I don't have an appointee yet, and I think I'm still a little confused on the scope of this particular committee. I think I was under the impression that perhaps we would give them some protocols or criteria, and that they would perhaps be then vetting whether or not, I guess, as applications kind of came forward, or as folks came forward wanting to name something. I think my concern is that if we're talking about the protocols for what qualifies somebody to have their name on a building, I think that's a discussion I'd rather have here at the board level first.
Well, I thought the idea was to get input on that, was what,
Right. And if you remember, Mr. Mock brought his presentation forward to us with some of the options, and so my thought was that the committee would look at his recommendations and have a conversation about, is that even something we want to do? We have a current naming policy. It's just a matter of, do we want to start using the sponsorship approach, or an approach where people would actually have to contribute financially versus just memorializing a field or an auditorium or a school, and what that would look like. So I would prefer that they would discuss it as a community, and even if it's an option that they would like to see, and then bring it forward to us to make the decision. I don't know that they would be the decision-making body.
they wouldn't be, but
Right.
then we would workshop whatever
Right.
ideas they came
Right.
up.
So this committee is going to, let me see if I've got this right. This committee is then going to look at what criteria we would use, or what we would even be considering naming to be eligible, or what the cost is for that sort of thing.
Hence, that's why I chose someone with a financial planning background for me, because I would run the numbers, because that was the intent, is if, right now, we have a policy on naming rights. But then if we go beyond that and start selling those rights, what does that look like, and what is that criteria, and kind of what is the number, that. So it's the beginning stages of what I think you're absolutely right, Mr. Dodd, would be a workshop, that we would get deeper based on this citizen committee, even seeing if there's public stomach for it.
Right. So it's even, are there unintended consequences? Is it not something that would benefit in Lake County alone? Decisions that we need to make for our local community versus just on a whole, this is what we're going to charge if you want to name a school after your company, or this is what we're going to name an auditorium. And there's been so many different instances too, I feel like, that we're still even kind of all over the place with that. So I know that we have fields being named just for memorializing, and then we have other fields that are being proposed to be named based on, like, we're gonna buy a scoreboard or a press box for $70,000, but this one was free, and so it seems to be a little wonky, and it may be an opportunity too for us to garner some more income for capital funds.
So is this particular group then? I guess I still get a little lost in this, in that I feel like this group is now being charged with the direction of, here's kind of what we're trying to implement, but I'm not entirely sure that we as a board have landed on that. And so, for instance,
I would tell you 100% I haven't landed. You know what I mean? So the idea of garnering whether information that we then would come back and discuss.
like some things I just don't even think should be up for grabs. For instance, somebody should not be able to just buy their name onto a school and diminish the accomplishments of the schools that we have named for people. So like for me, that's a non-starter.
I agree with you.
And would this committee now put forth a recommendation to say, oh, you can sell a school for $1 million? I just think back to the day Aaron Hernandez was charged with murder and arrested, and they instantly tore his statue down from outside of Ben Hill Griffin Stadium. That thing went up for 5 minutes. I mean, are we going to have murderers, memorialized, and suddenly we have to now go back and undo that naming process? Yeah.
We've certainly undone naming processes before, though, because if you remember, the Bragg Center used to be our Technical Institute, and we pulled that name off because it didn't.
I think that once they chartered, they took it down, and they took it down because at that time you couldn't be living.
Right,
Something
right. There was something in the policy that you couldn't be living.
Right.
So again, I'm not suggesting that if they bring it forward, we adopt it. I think that they bring it forward, and that's the opportunity that we have for discussion. And naming a school doesn't even have to be one that we would adopt if we didn't want to adopt it. But I've also seen in some schools that I've traveled across the United States at, where they've got a new digital sign out in front of their school, and underneath the sign, it said the name of the bank. And it didn't look gaudy, it didn't, you know what I mean, it didn't stand out, but the bank sponsored the new digital giant billboard that was outside of the school with all of the PTA announcements and the whatever. And so when we have schools, and we know very well that they don't have the funds they need to update scoreboards or purchase LED signs and have technicians that fix LED signs, like some of the conversations I've had, that this might be a way to garner some funds for those specific things, for those buildings. If we had banks in the community or personnel in the community that wanted to sponsor purchasing a scoreboard or a press box or a sign out front.
And I do think maybe it is a workshop that we have a discussion so that we narrow it down for the committee.
We can do that.
I think that would be probably prudent.
Yeah,
Because we're not going to take a school that has a strong tradition and suddenly sell it for
Right.
$20,000.
Yeah, I would feel more comfortable if we kind of gave them some parameters of what's on the table or what's off the table.
We can do that.
So I think that we have a workshop on it, maybe the next workshop, Superintendent, we could have a few minutes.
I think it's not until February or something.
Yeah,
Well,
that's all
I mean, I don't think anybody's
There's
jumping,
not a
throwing
rush,
dollars
right,
at us
right.
to
Right.
name
Yeah,
something right now.
There's somebody knocking on the door with $5 million. I'm going to just tell you guys that I appreciate this setup. I'm really having trouble having a conversation with Mr. Dodd. It's making me motion sick to look in this because I'm seeing the glare from the television, and I can see Steve Johnson, and I can see the superintendent, and I'm like, that's why I'm like, okay, I need to look at you, Mark, but I can't. I'm like gonna get sick, like really.
Okay. Well, thank
That
you
was
for-
really
thanks for
random. I
sharing.
apologize, but I can't look at you guys anymore. That's not okay. But
All right,
I'm
so-
not trying to be disrespectful and like.
So we'll begin to think about our committee, but we're going to have a workshop before they ever come together.
That'd be great.
That sounds good. I'll
that
give
okay?
my
Moving on.
appointees some more thought.
Chairman, I'd like to make a couple of comments, if I may, about that.
Yes, ma'am.
I think that was the concern of my appointee. He really felt that perhaps the committee needed some guidelines, and I think that goes along with a lot of what Mr. Dodd is saying. So I would certainly reiterate that I think as a board, we need to give them some particular, and we also need to know what it is we want them to do. So I would concur on that respect with him.
Very good input.
Yeah.
Okay, so the intent is
Excellent.
we'll have a workshop, and then move forward with the committee. Very good. Okay, superintendent's report.
Before we leave that topic, since you mentioned a workshop, I can propose to you February 1st, which would be the next available Monday. That would be a typical set-aside date for workshops, given that there are no Mondays available in the month of January. So we can certainly set some parameters for the naming committee at that, and we also have another item. We need to begin talking about the transition of Claremont Middle School, and so I'd like to have some discussion with the board about what that might look like and what we want to make sure that we want to make sure that we're can inform our employees as well as our parents about what that's going to look like for then the transition year as that school closes and then reopens as the Aurelia Cole Academy. So I'd like to maybe add that to that agenda as well.
I'm not entirely sure, maybe we can double check the date on this, but my notes, my calendar say that the first is the elementary science fair that day.
Oh.
And so if that is true, I know that the
Then
board
that would
members
not be a
typically
good day,
play an
would it?
active role in that, and I'd hate to
Okay.
compromise us from participating.
Yes.
If we're planning on, future workshops, could we add in ESE? It doesn't have to be February, but we've talked about looking at our ESE program with Melissa Lyford before.
No, that was February the 18th that I've already spoken to you about setting that date aside for a mid-year data review and technology updates. You can look at that agenda to see if any of these items might go on that agenda, but we might need to set a second February date as well. So I'll look at the calendar and get back with you on a date, and we'll certainly need to get science fair on my calendar. Thank you.
Well, if our February workshop is not on a Monday, is there any hesitation to looking at non-Mondays in January? If I guess just thinking about if we want to try to accomplish these topics sooner than later, I'm open to it, but I don't know the schedules of the board members in January.
I can make things
Yeah,
work.
I can make something work too. I teach on a Tuesday or Thursday, but I can't remember which one right now. I can't.
So that would be a Wednesday then, would work for you?
Yeah, I'd say it'd be good.
So, the 6th or the 20th,
Of January.
Wednesdays. Mrs. Cunningham, are you good anytime?
I don't believe January 20th will work. I have I believe that's the day of the Martin Luther King celebration, and I have a commitment there to their program.
Oh, how nice.
Okay, February 18th it is. We're set. Moving on.
We'll probably, the items that were just suggested is going to be a bit much unless y'all want about a 6 or 8 hour workshop, so we might want to find
I
another
think you
day.
can split it
as
up, because
well.
I don't know that.
Well, if
that
it's,
We've gone this long without having this committee. that
if
we
it's in
can-
the afternoon, I'm good. I think it's a
On the-
morning,
On the 20th?
yes, ma'am.
Okay.
Oh, do we want to do an afternoon meeting? Or,
We can.
so,
On
1
the
o'clock?
20th?
That would be fine for me.
That's good for you?
Yes, sir.
Okay.
Ms. Luke, are you okay
All
with?
right, we're back to the 20th at 1
pickups
o'clock. Dr.
from
Burns?
school?
I can get it covered if I know in advance, that's for sure.
We're good?
Okay.
Okay.
You can do that?
At 1.
1 o'clock on the 20th
Do that.
is our next workshop.
Got it.
I'll make it work, but if y'all decide that, that these are not pressing and you want to wait till February, that's okay with me too.
You're the one that brought it up.
Well, I didn't know everybody was so committed.
December 20th or February?
Okay, back to February.
Oh, okay. I was like, awfully soon.
Let's go ahead. Is you're all right with the 20th?
All right.
It may be challenging, but, because I think we're going to be in school dismissal. I've got high school, middle school, elementary.
Yeah, it's fun, and it's like
Okay.
12:30, 1:33,
Okay.
12:32.
Afternoon's
Time out.
problematic.
We're doing the 18th of February. Final answer.
I appreciate that.
Okay, we're good. Okay,
It was a
superintendent
noble
report.
attempt.
Okay.
But that's a
We may
Thursday.
Kind of, we'll work the agenda. We'll make it work.
All right.
Okay, superintendent report.
I'm going to start with, unfortunately, a long list of letters of condolences that have gone out since our last meeting. First of all, Mike Colley, he's a bus driver in transportation, lost his wife, Sean Colley. Dennis McDonald, building maintenance technician, maintenance and operations south, passed away. He's the father of Eleanor Orishan. I'm probably not saying that correct. And the grandmother of Melissa McDonald, who's a teacher at Gray Middle. Tammy Langley, who's the principal at Fruitland Park Elementary, lost her father-in-law, Raymond Langley. Monique Griffin Gay, who's the assistant principal at Leesburg High, lost her mother, Ruth Johnson. Christine Cavender, who's assistant principal at Lake Mineola High School, lost her husband, David Cavender. Chris Engel, who is a teacher at Leesburg High, lost his mother, Vivian Engel. And John Butch Myers, who is the brother of Dave Myers, our supervisor for compensation and employee relations, and he is the brother-in-law of Robin Myers, principal at Lake Hills, passed away this past week. And on Friday, Gail Widener, who is the finance and grant specialist with the Education Foundation, lost her mother, Donna Widener. So condolences to those families. Just a few things. I did send you earlier today the newly released graduation rates, and I have to say it was a nice Christmas gift for all of us. And it the rate of all of our district operated schools is actually 94%. The 91% that you saw reflected included Ali, which is our private charter school. So meeting that mark of exceeding 90%, and you can see the great improvements that were made across all of our schools. We knew that the rates were going to be higher because we knew that there was a waiver that the state provided that would allow students to graduate having not met either the Algebra 1 EOC requirement or the Grade 10 ELA. But keep in mind that those students typically would have had 3 more opportunities before school had closed to earn that concordance score. And many of those students do go on to earn that concordance score. So our college and career folks did a little bit of work to kind of look to see with the numbers and the percentage of students who actually earned the waiver and what the results would have been. And I can tell you it wasn't a whole lot less. It would have been right at 89%, 90%, even if the waiver had not been applied. So still right at that 90% mark, and we just know that this is a true testament to the great work that's happening in our high schools. The role of mentoring and really targeting students and supporting their needs has just been a tremendous effort on the parts of our teachers and staff. Our graduation facilitators have played a key role in that, and our guidance counselors and school administrators all just really rallying to ensure that every student walks across that graduation stage. And I'm just so proud, and just want to say thank you to all of them who are just contributing so much to the success of our kids. I also want to congratulate the Lake Mineola High School Hawks. They won the state semifinal 6A championship game on Friday. It was a hard-fought game going into triple overtime, and those kids, I tell you, they did not give up. Their perseverance and just the camaraderie, and it was a fabulous game, and just really just want to congratulate them as they head to the state finals for the 6A state championship on Friday at 1 o'clock at Doak Campbell Stadium in Tallahassee. So I know, wish they were headed to Gainesville, but they're headed to Tallahassee. Just wish them all the best as they head north. And I just want to say thank you to this amazing district staff who has, our folks in our transportation office. They have filled a bus with donations for local charities, for needy families. Our district employees donated toys and other items for local children through the Salvation Army. Schools are helping families and adopting families in this season. And in the midst of this pandemic and all that, the uncertainty and fear that still continues to surround us, there's such a great place to be as we just embrace one another and just show the concern and care for others in our community. Just want to say thank you and how proud I am of all of that, and wish everyone a very safe, happy, and a very healthy holiday. Everyone behave. And school will end Friday and resume again on January the 4th. And I want to wish Mr. Johnson a happy birthday today.
Thank you.
Dr. Burns, we'll start with you.
Oh, okay. I don't have much. Happy birthday, Mr. Johnson. Let's see. I did do a concurrency meeting. It was pretty straightforward for you guys. Are we supposed to be going to the concurrency meetings more than once a year?
No.
Okay. So I guess I went as the final job of the chair. So that seemed to go fine. And really, other than that, I just have, I did, I think throughout this whole pandemic, as a scientist, I know how things can roll out and how hard it is to get to that vaccine, and I didn't ever know for sure how long this would take. And so I'm really, really just beyond thrilled that the first vaccines were given today, and that it will take time. I think children are going to have a second study, but teachers will be inoculated, and I hope we can get it through it by this summer. That would be my hope, but manufacturing is always the hardest part. Or one of the hardest parts. So anyway, hopefully we can all look forward to an end to this pandemic, because I am beyond over it. And beyond that, I just want to say happy Hanukkah to everybody. Merry Christmas, happy holidays.
Thank you, Dr. Burns. Mr. Dodd?
Yes, those graduation rates, my goodness, I don't even know how to begin to express how excited I was when you had referenced this early Christmas present, and I wish I could have unwrapped the phone with a little bow on it to open that email, because that surely was nice and certainly a great testament to everybody's hard work. I remember when you were interviewing for the job of superintendent, how important you reiterated that graduation is for our students. It's the culmination of this 13 years that we've invested in these kids, and so to see so many more kids graduating now is evidence of a lot of great accomplishments and hard work over the years, and think we're going to be continuing to cross more and more thresholds with that. So that's fantastic as we keep that work going. This week I received a call from a parent who is, I think, struggling with this pandemic just like we all are in our own ways. This parent has a kid who's somehow found the misfortune of being in close contact a few times with somebody with known COVID and has gone out on multiple quarantines. And I thought, this is like the perfect example of why the state needs to really seriously give some thought as to what they're going to do with our school data at the end of this year. And I know it's our priority, as well as every other school district in the state, that we not face some adverse repercussions with that we use it truly as informational data. And I guess I want to put that plug in there every opportunity I get. You know, it's hard, you know, for a kid to constantly be out for a couple of weeks at a time from school, and then you go back and try to get yourself reacclimated to the being around other people and learning live, and then suddenly you're out again for a couple of weeks. Our kids are going through a lot, and that's one of those things when you give the whole listing of here's what the score doesn't tell you. This is one of those things. This is another one to add to the list of here's what that score doesn't tell you about that kid, and that story. And I think as I reflect on this time of year, part of the challenge for me as a parent is how many of these events that I guess I didn't realize that I looked forward to attending as a parent, and now we've got, you know, kids doing so many of these events in school, and those doors are closed to visitors, and it just, I think it becomes harder and harder for us to be able to create that school and home connection that is just so important. So, you know, I think I'll be looking forward to seeing hopefully some community rates drop as this vaccine rolls out, and I look forward to the day that we can create those stronger connections back in place. And with that, I just want to wish everybody happy holidays and a very refreshing winter break.
Thank you, Mrs. Cunningham.
Thank you. I also had an opportunity this past week. I received an email from one and a phone call from another, two graduates of Lake County that were graduating from college, one from FSU and one from Bethune-Cookman. And in speaking with the pandemic, their parents were having Zoom celebrations, and they asked that I make a speech to be played at the graduation celebration, and that was quite a new experience for me. But I can tell you with confidence that not only are our children graduating, but they're going on to colleges, and they're doing really well. Both these young ladies graduated with honors, so that's very nice. I'd like to put a plug into, especially to our listening audience, for our assistant superintendent. I was most impressed with our state plan that was submitted on what we're going to happen next semester. I was especially pleased to see that many of the instances of things that the governor in his order said that had to be done were already happening in Lake County. That made me very excited to be a part of that, knowing that while it's the governor's order, you know, we're already doing it, so we're ahead of the game. The other thing, of course, I was very pleased with the graduation rates. I thought those were wonderful, so congratulations to all of us. And I guess this is my first time receiving cookies, so I'm happy to also be a part of that tradition. So with that, I'd like to wish everyone, first, Mr. Johnson, happy birthday. And I'd like to wish everyone else happy holidays.
Thank you. Mrs. Luke?
Okay. I don't want to restate what everybody has said, so I'm not going to. Congratulations on the graduation rates. It's a huge accomplishment, and Lake Mineola was on my list, and Merry Christmas and Happy Hanukkah and Happy Holidays and Happy Birthday, Steve. And so I appreciate the time that we all get to spend together and the work that's been done in this district. It's truly been a year, and I know that the new year is always a time, for whatever reason, that I kind of sit and think about things that I've learned and how I've grown, and this year is going to be exceptionally different from years past. And so I appreciate all of the work everyone, from all of our employees to all of our students, have done throughout this fall and this spring and this year. So thank you.
Thank you, Mrs. Luke. I have to say, for 38 years, every year, I begin to get anxious because it's a resetting of the clock for my business, primarily, actually, mostly. this year, I cannot wait for 2021. So let the clock reset. I was reflecting tonight, and part of my conversation with Mr. Wolfmeyer was, today was the first day that I had an opportunity, and it's always difficult when we lose an employee, but sometimes there are just folks that just don't need to be part of our team, period. And I was reflecting, my dad, after he left public service, he would be hired by Duval County Schools, a small group of supervisors. It would become the supervisor union. And Dad promoted excellent. And if you wanted to be a member, you had to be stellar. And that was the strength of when Dad was at the negotiating table, that they knew that these were the best of the best. And I think that the most disappointing thing for me that I learned was with Mr. Wolfmeyer, and I wanted him to confirm it, that he was hired by the teachers union that should be a partner with us in promoting the best. And that is not what we saw today, and it was very disappointing to me. And I think it would be disappointing for all the hard-working teachers, and so that's all I have to say about that. So with that said, meeting adjourned.